Welcome back to Face the State. I'm Arianna Bennett. Thank you for keeping it here. And one of the challenges of new technology is that laws sometimes struggle to keep up, and artificial intelligence is providing a lot of ground for debate about the right way to regulate it or not. So I'm back with you and our Professor Patrick File now. Patrick, thank you again for your time. Sure. Always great to have you. Okay, so my first question. If someone uses ChatGPT to write something and then they publish it under their name, is that plagiarism?
Is it plagiarism? University policies generally say, yeah, that's academic misconduct where you don't indicate that that was something that you used, right? Even academic journals are now sort of saying use of ChatGPT is acceptable where you are transparent about the fact that you used it, right? And so, if you're telling whoever it is that is reading this that you've used ChatGPT or other AI, large language model, technologies to develop your work, then that's acceptable. But where you're sort of passing it off as your own, I think, yeah, that's going to fall under kind of plagiarism. I mean, that's what I tell my students, that if you're passing this off as your own and not telling me, then that's a problem.
Yeah. So this leads me to the question of when you generate something that's sourcing bits from all over the internet using a machine that was created by someone else to build it, but it is a unique thing now that you prompted. Who owns it?
Right. Yeah. I mean, the Federal Copyright Office has given a little bit of guidance on this, but they're also kind of punting it out to the courts, which is to say that the question of authorship is really what we're talking about here. And in order for copyright to exist, for ownership to exist, you have to have an author. And what the Copyright Office has said is that just prompting an AI to do something for you, to create an image, to create some text, to create a motion picture of some sort, that's not sufficient to be authorship. And so that work should be in the public domain. And something that isn't owned by anybody. But there is going to be a threshold where, more than just a prompt, editing like you would with Photoshop or other types of tools that, again, this isn't all entirely new technology, right? There is a threshold where authorship kind of attaches and copyright can, be owned by the person that claims to have created the whatever it is.
Okay, so I decide to make a deep fake of you. If under those rules, and I have you, I don't know, doing something, let's say not obscene, but something that you just don't like,
sure,
right? Do I own that? Probably not until I publish it, right?
Right.
So I publish it. Have I broken the law?
It depends, of course, is always the answer when it comes to law, particularly when it comes to law and new technologies. So a couple of things are happening. Various states are looking at kind of regulating deepfakes and the creation of things. Basically, it's where you're putting words in someone's mouth or making things happen, appear to have happened that didn't actually happen. Which again, that kind of manipulation has been possible prior to AI. It just took a little bit more work, maybe a little bit more expertise, and a few more hours to do it. Were I the person who's kind of the target of this content, there are a couple of ways that I could go about, again, if from a legal standpoint and I don't like what you created. If it's false, obviously, it didn't happen, and I think I want to argue it harms my reputation, right? You put words in my mouth that I didn't say, and people now think differently of me, think badly of me. I can sue for defamation. I can file a lawsuit for defamation. There's also a realm of publicity law, right, of publicity, which is to say that people can't use your image or your likeness without your consent to make money. Lots of states have laws, Nevada is one of them, that has protection for the right of publicity. And so I could file a lawsuit saying, you're profiting off of this, or you're using my image, my likeness without my consent in a way that I don't consent to, and I could file a lawsuit over that. That's kind of a couple of examples of sort of what might happen legally out of that.
So this is just using our existing body of laws in this way to be able to now apply it to a newer technology. Do you think we need then new laws for this new technology, or does what we already have pretty much cover it?
In a lot of cases, what will happen is a new technology will be developed. It'll kind of raise a social concern, kind of a sort of cultural outrage. Often for good reason. I mean, where these new technologies are put to use and people are alarmed by it, and they're alarmed for good reason, laws will be proposed. and new ideas will be proposed as kind of ways to regulate this technology. As often as not, a couple of things will happen. Some holes will start to get poked in those new laws, and you'll realize that, okay, we wrote this too broadly, or it turns out that this law isn't working maybe the way that the people who wrote it intended to work. And we end up kind of reverting back to sort of some of the old case law or some of the old statutes that applied to previous forms of technology. The general rules are that it's, at least under the First Amendment, banning entire technologies doesn't usually fly. What you do is you target misuse of those technologies, right? We don't tell people they can't use a camera, but invading people's privacy using a camera, or again, maybe invading their right of publicity using a camera, maybe that's something that we can deal with through regulation or through lawsuits. And so, generally speaking, new technologies create new problems, and we look at new laws to deal with them. And in some cases, that's something that's necessary, or it can be a tweak to older laws that will kind of add a clause or add something new to an existing law that will kind of make it clear that that certain uses of these new technologies are not going to be considered protected.
Yeah, super interesting. We have almost no time left, which is really a bummer because it's so interesting. But really quickly, I know parody also plays a role here. So say I argue like, oh, I made this video of maybe not you, or maybe a politician or something, but it's funny. It's meant to be parody. Does that exempt me from any possible consequences?
Not necessarily, but there is, traditionally very strong protection for satire, for parody, where it involves public issues and public people. I mean, this is the kind of, blanket exception for things like Saturday Night Live, right? When somebody gets up on stage and in front of a camera impersonates someone famous, there's not an expectation that the famous person can come back and say, hey, you misrepresented me, and that's not fair, and I can sue you.
But with a deep fake, it is their actual face.
That's exactly right.
So this is so complicated. We only have 30 seconds left, so I'm so sorry, but final message about this.
Well, I mean, just that I think there are legitimate concerns about these uses of technology, and I think that for that reason, I mean, we should expect lawmakers to take a very close look at them, and be concerned and kind of voice our concerns, but at the same time, there's a lot of law and doctrine that can cover these things.
Okay, Patrick Fowle, thank you so much for your time. I do appreciate it. Coming up on Face the State, actually that's the end of our segment for now, but we thank you so much for being with us. All of our episodes are posted at 2news.com. We'll see you next week.